There are now 2 federal cases involving the words the United States versus Donald J. Trump, both brought by special counsel Jack Smith, each making an extraordinary set of allegations. In his criminal probe into efforts to overturn the 2020 election, the 190th person to be charged in connection with the insurrection, according to one count, is a former president and a current frontrunner for the nomination of a major political party who's already facing 74 criminal counts and stands accused of trying to defraud the government that he led at that time, trying to obstruct the proceedings of a branch of government, and trying to overturn the will of millions of voters in the swing states that determined the outcome of the Electoral College. The big question, now that Trump has been booked and fingerprinted, what's next in this case, which is really unlike any other in American history? Here's what Team Trump has planned, according to the New York Times. His lawyers used the arraignment to hint at one of his central defense strategies, a request to delay a second pending federal trial for months, if not years. Delaying the proceedings as much as possible is widely expected to be part of Mr. Trump's legal strategy, given that he could effectively call off federal cases against him if he wins the 2024 election. In recent days, the defendant and his lawyers have been banging the drum about a change of venue, complaining about the impossibility of getting a fair jury in D.C., and suggesting that deep red West Virginia is a reasonable site for a trial. The New York Times reports the jury selection comes with a unique set of challenges for Trump's attorneys, but not necessarily in the ways that they've been suggesting. From that reporting, quote, "It's not just that the pool of potential jurors in the District of Columbia is heavily Democratic, though it is, or that the city is home to a great many lawyers, 1 in 40 residents, the most per capita of any state or district, according to one estimate. To many of the district's residents, the mob attack on the Capitol on January 6, 2021, was more than a national political crisis. It was also a horrific act of local violence that felt deeply personal." Joining us now, former acting U.S. Solicitor General Neal Katyal, plus former Assistant U.S. Attorney Glenn Kirshner, and MSNBC host and legal analyst Katie Phang. It is great to see you all. Neal, let's start with the arraignment yesterday and what happens next. Did we get a glimpse yesterday into how Team Trump is expecting to handle the case?
Yeah, absolutely. I think we did in 2 senses. One is the delay tactics that they want to use. One of Trump's attorneys said outside the courtroom that Jack Smith has had 3.5 years to investigate this case, so they should get 3.5 years. It don't quite work that way. I mean, there's several problems with that. I mean, one is 3.5 years ago was like January of 2020, well before the election. So nobody was investigating Trump at that point in time. But, you know, more generally, there is no such symmetry rule. And indeed, the system would grind to a halt if there was. So I don't think that these delay tactics are going to work. They might work better in Florida in the stolen documents case where you have classified information and things like that, but not here. The other thing I think we heard a lot of yesterday is this, as you said, change of venue. The trial can't take place in Washington, D.C. And Alicia, that is going nowhere fast. That was the same argument. I was special prosecutor in the George Floyd murder, where the city, of course, was under, the city was, scene of violence for a long time right after the murder. And the officers tried to change venue because of that, and the courts rejected that very quickly, basically because the legal rule is that that you take the trial in the place that the crime occurred. That's what the Constitution says. And the other point is sometimes if there's a lot of pretrial publicity in a particular place, then you can move the trial. But in a case like Floyd, in a case like January 6th and Trump, there's publicity everywhere about the trial in every nook and cranny. So what Trump really wants, and his lawyer I think actually, Trump himself said this in a social media tweet. He said, well, I want to move this to West Virginia because that's a politically better state for me. Again, there's no such defense in the law. That is going nowhere. You don't get to get tried by a jury of people who like you more. You get tried in the place where the crime occurred. And here, I think the symbolism, just returning to your question about the arraignment, the former president of the United States yesterday walking into a courtroom in Washington, D.C. on Pennsylvania Avenue, 16 blocks away from another building on Pennsylvania Avenue, the White House, where he's formerly served as our leader, and just a few blocks away from the United States Capitol, where he fomented, basically an attack on that building. Of course, the trial has to take place in Washington, D.C. There is no other place for it.
Right. I mean, Glenn, understanding that 3.5 years, West Virginia, those may be more political arguments than they are legal arguments. I wonder what you make more broadly of the delay tactic. I mean, could this potentially delay the trial till after 2024?
No. Delay will not work because Judge Tanya Chutkan is presiding over this case. I had the pleasure of trying murder cases many years ago against Tanya Chutkan when she was a public defender in Washington, D.C., and I was an assistant United States attorney at the D.C. U.S. Attorney's Office handling murder cases. And back then, she, distinguished herself as a smart, strong, tactically savvy, no-nonsense criminal defense attorney who was also entirely honest, ethical, and trustworthy. I don't always say I enjoyed trying cases against a particular defense attorney, but I can honestly say that with now Judge Chutkan. I've also seen her presiding over criminal matters more recently. And, she is a no-nonsense judge. And she is not to be tested or trifled with. She will give the defendant a fair trial. About that, I have no doubt. But she will also give both the defendant and the people, the prosecution, a speedy trial. So I don't think Donald Trump or his attorneys' tricks and attempts to delay will work. And I think that was proved when the specter of Judge Chutkan hung over yesterday's arraignment hearing. I was watching it from the overflow courtroom. And toward the end, the magistrate judge said, "You will both file briefs with your proposed trial date." The defense mightily fought against that, but they lost that fight. And then on the 28th of August, Judge Chutkan will set a trial date. I suspect we're going to see a trial date in the near term, whether it's January or February. But I think Donald Trump and his lawyers have met their match because they have a fair, no-nonsense, determined jurist presiding over this case.
Katie, speaking of Trump's attorneys, there's what they say in the courtroom, there's then what they say on cable news. I want to play something for you that Trump's attorney John Lauro said on Fox News just last night, defending what his client, Donald J. Trump, tried to do on January 6th.
But ultimately, what President Trump said is, let's go with option D. Let's just halt. Let's just pause the voting and allow the state legislatures to take one last look and make a determination as to whether or not the elections were handled fairly. That's constitutional law. That's not an issue of criminal activity.
And here's a bit of what prosecutors allege in the indictment. This is from a January 4th meeting. Quote, the defendant and co-conspirator 2 then asked the vice president to either unilaterally reject the legitimate electors from the 7 targeted states or send the question of which slate was legitimate to the targeted states' legislatures. Jack Smith, Trump's lawyers, they're not exactly disagreeing here, Katie.
They're actually not in disagreement, but most importantly, John Lauro was going on TV and asserting a law that doesn't exist. I mean, he's saying that there was the opportunity for Mike Pence to delay the count, and that's not possible under existing federal law or the law that was in existence back then. I think what you're seeing is a new criminal defense lawyer for Trump world trying to float a test balloon of a theory so that he can taint the jury pool. Donald Trump knows that there is no sympathetic jury pool for him in D.C., so he's hoping that if he puts these random theories out for consumption, that perhaps it will take hold on maybe one, because as we all know, it only takes one holdout in order to get a hung jury for a criminal case. I think what's problematic, though, is if you really look at this indictment, Jack Smith made sure it was clear that he anticipated these types of defenses from Donald Trump. We see it at the beginning of the indictment, where Jack Smith makes great haste to dispose of this idea that this is an attack on Donald Trump's First Amendment free speech rights. he acknowledged that Trump could say, I won that election fair and square, but there were legal remedies by which Trump would have to pursue to be able to find the truth in that. But the reality is it was all a lie, and Donald Trump knew it was a lie. And when Donald Trump basically started a pressure campaign that went from state officials to fake elector schemes to the Department of Justice, and then finally Mike Pence, the only thing that was left was for Donald Trump to call upon his supporters to exact violence on January 6th. So John Lauro is going to do the best job that he can. But really, to your point, there's the court of public opinion, and then there's the courts that Glenn and Neil and I know very well. And those theories just don't fly in a real courtroom.